Good morning, sir. Can you see and hear me?
Yes, I can. Thank you very much.
And we can you. Thank you very much. Can I call Anthony Oppenheim, please?
Yeah.
Good morning.
If you repeat after me, I do solemnly,
I do solemnly,
sincerely and truly
sincerely and truly
declare and affirm
declare and affirm
that the evidence I shall give
that the evidence I shall give
shall be the truth,
shall be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
Thank you, Mr. Oppenheim. My name is Jason Beer, as you know, and I ask questions on behalf of the inquiry. Can you tell us your full name, please?
Anthony Edward Peter Oppenheim.
Thank you very much for coming to give evidence to the inquiry, and thank you also for the witness statement that you've previously provided to us. We're very grateful for the assistance that you have given and are giving in the course of the investigations by this inquiry. You should have a hard copy of the witness statement in the folder behind you in volume 1. Could you take it out, please? And in tab A1, there should be a witness statement which, excluding exhibits, is 85 pages in length and dated the 7th of September 2022. And on page 85, there should be, excuse me, your signature.
There would have been, but it's got GRO on top.
It's been redacted. Okay, well, that's an error by the inquiry staff. We'll correct that later. Does it look like the witness statement that you did sign?
Yes, it does.
And were the contents of it true to the best of your knowledge and belief?
Yes, they were.
A copy of that witness statement will be uploaded to the inquiry's website. I'm going to ask you questions, not about every part of it, but just selected parts. Do you understand?
Sure.
Can we start with your background and experience, please? I think you were employed by ICL from 1979 and left Fujitsu in 2018. Is that right?
That's correct.
And so you were a company man for the majority of your career, just shy of 40 years.
That's right. It wasn't the first job, but the majority certainly.
By training, you are an engineer and an economist.
Yes.
And so far as concerns this inquiry, would this be right? The most relevant part of your employment occurred between 1994 and 2002.
That is correct.
It began in October 1994 when you joined the Pathway bid team.
Yes.
And I think you were one of the first to join.
That's correct.
You were then Pathway's commercial and financial director, is that right?
That's correct.
You say in your statement that you became a member of Pathway's board on the 15th of June 1995, and by that do you mean the board of ICL Pathway Limited?
Correct.
You left ICL Pathway in February 2001, going back to ICL itself, is that right?
Yes, it is.
But you retained some responsibilities for ICL Pathway, namely the commercial and contractual arrangements between ICL Pathway and its customers and its subcontractors, is that right?
No, it was a higher level overarching responsibility for the commercials only and not the financials. So just to elaborate briefly, Pathway then was one of a number of major accounts that I was responsible for commercially. I think the initial title was Commercial and Finance for Major Projects, but it was quickly reduced to commercial only. So I was brought back in later, you may go to this, to negotiate with POCL, or POL as it was then. But no, I didn't have day-to-day responsibility.
No, I wasn't suggesting day-to-day responsibility. Perhaps you can tell us exactly the level of responsibility that you had after February 2001 and before December 2002.
Virtually none. It was a sort of monthly review of high-level reports, and that was it. So I was replaced in my previous role by a guy called Colin Lenson-Smith.
Were you involved in any negotiations after February 2001 and before the 31st of December 2002 concerning ICL Pathway?
No.
Your involvement with the Horizon system, as it had become, ended entirely, is this right, in December 2002?
That is correct.
Can we have a look at your witness statement, please, at paragraph 14? That's WITN 03770100. It will come up on the screen for you, Mr. Oppenheim.
Mm-hmm.
And look at page 4, please. And then highlight paragraph 14. You say, I was involved in setting up all the arrangements above. That's the creation of ICL Pathway Limited, the relationships with ICL Pathway shareholders, and the engagement of the principal subcontractors. That's what you've been speaking about above.
Correct.
Then you continue the management of contract changes between 1996 and 1999, and then in 1999, unwinding the benefits payment card part of the contract. Is that a fair summary of the principal parts of your role over time?
Yes.
Can I turn to, in slightly more detail, positions of responsibility and roles within ICL Pathway between October 94 and February 2001? I wonder whether we could look, please, at Fujitsu 6060. This is the first exhibit to your witness statement, a document that you will recognise.
Yep.
And for the note, I think this is part of Schedule A14 to the codified agreement of 28th of July 1999. Does that figure 1, the Pathway Board, accurately describe the 5 members of the Pathway Board and their job titles at that time, as at July 99?
Yes, it does.
So Michael Butler as the chairman, Mr. Todd as deputy chairman, you as commercial and finance director, Pathway, Mr. Bennett as the MD of Pathway, and then Mr. Christou. It says ICL legal and commercial director. What's the significance of ICL being written against his name and Mr. Todd's name rather than Pathway against yours and Mr. Bennett's name?
Because they were not executives of ICL Pathway. They were executives of ICL, and they were board members of ICL Pathway.
On the next page, if we go over the page, please. There is an introduction to what is called the Pathway Management Team. Can you see under paragraph 2 in bold, there's the heading Pathway Management Team, and the codified agreement says the Pathway team is in place, the management structure has been agreed and the positions filled. The structure of the team is as follows, and then it says figure 2, the Pathway Management Board, and we see a place where a diagram or a figure is supposed to appear, but it is blank, at least in this version. You'll see that the title to the missing figure is in fact to a Pathway Management Board. A couple of questions arising from that. Firstly, was the Pathway Board that we saw on the previous page as it was described, the Pathway Board, the same thing or a different thing to the Pathway Management Board that we see in the title to Figure 2 on page 2 of the document?
I would say different. It's I agree, slightly confusing combination of management and board. This would have been the operating team as opposed to the board.
Sorry, it's a poor question from me. To start with, was the Pathway Management Board different from the thing that we saw on the previous page, which was described as the Pathway Board?
I suspect so, but it would be quite helpful to see the diagram, of course. I think it refers to somewhere else, but obviously not here.
We'll go to some other documents in a moment. And the second thing, was the Pathway Management Board different from the Pathway Management Team?
Again, without seeing the diagram, I can't be sure, but I think this was probably meant to be the Pathway Management Team.
So that heading might, or might ought to have said Pathway Management Team. Okay.
Well, the heading and then the beginning of 2.1 talk about Pathway Team, so I would think that's just an error in the Figure 2 description.
Can we look at FUJ 6061, please? Again, this is another exhibit to your witness statement. This is an ICL pathway organogram, a basic organogram, under the heading of ICL Pathways Directors. And can you see in the bottom left, it appears to date from 2000, right at the foot of the page.
Yes, I can see that.
Notwithstanding the heading to the document indicating that it concerns ICL Pathways Directors, does it in fact depict only directors or other people as well?
No, I'd say this included obviously the managing director, and I was a director, but all the others are part of the management team that we were talking about a moment ago.
So is this in fact a better description of the management team that we saw missing from the version of the codified agreement that we've just examined?
It is, except that this is a later version than that.
I.e. 2000. Yeah.
Yes.
So thinking back, would you say this is a fair description of the pathway management team?
Yes, as it was at 2000. It had changed slightly, but yes, as of that date, yes.
Now we see you're on this organogram, the third box down on the left, and we see that you're in a reporting line straight to the managing director.
Yes.
And is that correct, that your report was straight through to the MD at this time, Mike Stairs?
Yeah, correct. Yes, it always was. Yeah.
And the people on the left-hand side of the organogram, underneath, ignoring his PA for the moment, on the left-hand side of the diagram, Mr. Foley, Mr. Muchow, and Martin Bennett. Again, did they report directly to the MD?
Yes, they did.
And it's only the people on the right-hand side of the diagram that appear to report through Mr. Coombs, the Deputy MD, to Mr. Stairs. Is that right?
That is correct.
And so does it follow that people such as Mr. Austin, Terry Austin on the right-hand side, Mr. Flynn in the middle of the right-hand side, people responsible for development and implementation, they did not report to you?
Oh, that is correct. They reported to Mike Coombs, who, apart from being a deputy MD, was program director.
lastly, can we look at a further version of the codified agreement to see how the Pathway Board had changed? This is Fujitsu 6062, and again, this is exhibited to your witness statement. This version of Schedule 14 to the codified agreement is dated the 21st of July 2000 and is version 1.4. I think you can see that from the bottom right.
Yep.
Starting with the Pathway Board by then. Thank you. It says the Pathway Board has been set up under the chairmanship of Richard Christou, the ICL Legal and Commercial Director, with board representatives from ICL. And we can see in Figure 1 the depiction pictorially of the ICL Pathway Board at this time. And just looking how things have changed by now, Mr. Christou, who was formerly the Legal and Commercial Director, has become chairman of the board, correct?
He was still ICL legal and
I'm sorry.
yes.
I missed what you said there. He was
still legal director of ICL. Previously, he'd been just a board member, but his overarching role was still legal and commercial for ICL.
back in ICL parent.
Yes. So in addition to that role, he'd taken on the chairmanship from Sir Michael.
Mr. Todd remains the deputy chairman of the board.
Yes.
Mr. Stairs has taken over from Mr. Bennett as Pathway Managing Director.
Correct.
Mr. Bennett is described as ICL Government Managing Director. Can you help us? What does that mean? ICL Government Managing Director.
I think there's a word missing. It's probably government business unit or some such. So he'd moved out of Pathway, ICL Pathway, and back into ICL, taking on a new senior role for a part of ICL's business which faced off to, dealt with UK government.
And so the descriptions that are given underneath each name, one shouldn't be misled into thinking that's the role that they are performing in ICL Pathway. That's a description of their role, in this case, back in ICL, the parent company.
Correct. These are their day jobs, and in addition, they are, in a sense, non-exec directors of ICL Pathway. The same applies to Tim Escudier. Likewise, ICL Financial Services Division or whatever.
And Mr. Escudier has been added. He is described as ICL's Financial Services Managing Director.
Yes.
Again, that's back in ICL itself rather than ICL Pathway.
So John Bennett and Tim Escudier were peers running different business units within ICL. Correct.
Can we go over the page, please? We now see that in this version of the contract, Figure 2 has been completed. The rubric is the same. ICL Pathway Management Team as the heading. The announcement that the ICL Pathway team is in place, the management structure has been agreed, and the structure of the team is as follows. The cross-heading still describes this as the Pathway Management Board, and just take a moment to look at the organogram.
Yep.
Does that organogram describe the something called the Pathway Management Board, or does it describe something called the Pathway Management Team?
Management team.
We see in documents, hundreds of documents, the phrase Pathway Management Team, capital P, capital M, capital T. That was a term of art, essentially.
Yeah, that's how this organogram should have been described.
And does that show, again, that those responsible for example, implementation, customer requirements, and development did not report to you?
Correct.
And does that represent the position in reality? Those responsible for implementation of the program, the development of the program, and customer requirements didn't report to you?
Correct.
We're going to see that later on you had, later on today, rather than later on in the piece, you had quite some involvement in issues concerning the development of the project, the implementation of the project, and the customer's requirements. You were present at a number of meetings at which those three issues were very much the hot topics.
Yes, that's true. I was involved, but I wasn't responsible for them. If I can just clarify, if I may, there were a lot of tensions around the commercials. My main responsibility here was to take care of the commercials vis-a-vis BA and POCL.
Just stopping you there, sorry to interrupt you. You may understand what the commercials mean.
Yeah.
Could you explain it to a naive audience?
By all means. Commercials.
Mr. Oppenheim, can I interrupt you? Before you give that answer,
Yes.
I hope it won't take you out of your stride. It would help me if the document could be taken down once we've looked at it so that I can see Mr. Oppenheim better. I can see you, but not very well. That's great. Thanks very much.
Thank you.
So commercials was a sort of shorthand form of describing some of the things you talked about in your introduction. So contracts with BA and POCL, and the codified agreement was the one that operated through most of the piece, but prior to that there were several other contracts. There was the BA contract, the POCL contract, and the combined contract, because it was a tripartite set of agreements. So that was one piece. Then there was the piece with subcontractors, and we had a lot of subcontractors. And so that also was a commercial / contractual matter, which I had overall responsibility for. And also you mentioned, I think, funding, financing, so I had responsibility for that as well, trying to get the monies lined up for this project, because it was a PFI project, so we needed that as well. So I won't go on. That is essentially what commercials mean.
Thank you.
And then the ongoing operation of change control, pursuing agreements to agree, and such like.
And so I interrupted your answer there, and you were explaining to me why we see your footprint on a number of the documents, a very high number of the documents, when you had no management, directorial responsibility for issues such as development, implementation, or customer requirements. And it's simply because they all impinged on commercial issues. Is
Absolutely.
that right?
Spot on. Correct.
Not because you had any particular management or directorial responsibility or any technical expertise.
I had to acquire sufficient technical expertise to be able to deal with, to understand the issues, to be able to deal with commercials. There's a lot of this, I repeat, this was a PFI. There was a lot of tension between the parties as to who would be responsible for what. And in some cases, there was a great deal of detail that needed to be understood in order to get the wording right, to get the terms and conditions right. Had to do with risk management. So I had to understand the detail at a pretty granular level.
We'll come back to examine that understanding later today. You mentioned there that the PFI contract and the consequences of it. In your statement, you tell us that there appeared to have been a conflict between the benefit agencies and Post Office Counter Limited's business objectives. Is that right?
There were conflicts, yes.
And when was that conflict first appreciated or understood by you?
Right at the beginning.
And the beginning meaning what? From 1994 onwards?
Yes.
And so it wasn't only after you entered the contract that this conflict emerged. It was evident from day one.
It was implicit and visible in the terms of reference for the contract. If you thought through what, at a second level, that meant in terms of the interactions between the parties. I would say we understood that from very early on, and it was part of our risk register from very early on.
When you say part of your risk, it was written down, was it?
I believe it was, but I'm casting my mind back a long time now.
Was there a document called risk register?
There were risk registers, yes.
Who was responsible for maintaining the risk register?
Martin Bennett.
And can you recall now the format in which they were kept?
I think over the period, it evolved from probably Excel at the beginning during the bid phase to, I can't remember the particular application that was used, but there was an application which was used in ICL and we used that, but I can't remember the name.
And it was Mr. Bennett who had responsibility for that?
Yes.
Was there any team underneath him that was responsible for feeding into the risk register?
He had, from memory, at least one person working for him, Graham somebody. Can't remember his surname.
Thank you. With responsibility specifically for the risk register?
Well, in a sense, they both had responsibility for the risk register. I wouldn't like to say one was responsible for maintaining it and the other one for inputting into it. It was a team task.
Thank you. And was that ever escalated to the ICL Pathway Board for review and sign-off?
Sign-off, I can't remember about sign-off. Certainly, we talked about the major risks at the board, and this one would have been one of those. The inherent conflict and the conflict's a bit strong. It's a conflict when there's a problem. At the outset, it's a different set of priorities, perhaps.
And putting it shortly, we've got a lot of evidence on this from other witnesses and in the documents. But one of the purposes of the proposed system was, from the benefits agency perspective, to eliminate fraud.
Encashment fraud, yes.
But Post Office Counters Limited business goal was to seek to make customer experience as frictionless as possible, I think you describe it as, and therefore to encourage usage. Is that right?
Yes, I think that's an accurate description of the difference in priorities.
And so the benefit agency wanted not only a different means of payment, but tight controls, therefore. Wasn't, therefore, the benefits agency withdrawal from the programme always likely?
The reason we felt confident that they would go through with it, and we were proved wrong, was that at the time we were assured of a very strong political imperative from the government. And in a sense, we relied on that to push it through.
Did that, to your recollection, enter the risk register, the risk of the DSS withdrawing from the programme?
I don't necessarily recall, no, I don't recall it being in the risk register. I do recall discussions, certainly at the board, about that. Were those discussions right from the very beginning? I would say no. I think at the beginning the discussion was much more around the success, the success of the program and the chances of problems on the program, and what those problems might be, what those issues or risks might be.
Do you think that there is a possibility that the persisting questions over whether the system that was being developed best suited the objectives of the benefits agency on the one hand and Post Office Counters Limited on the other, got in the way or obstructed the delivery of a system that in fact best suited the needs of sub-postmasters?
I understand why you would ask that question. It's difficult to give you a definitive response. All I would say is this. We're going back, as you said at the outset, 25 years. And there was no internet then. And in a sense, the choice was, do you have an offline system, so you can't do any verification of a banking transaction, or do you have a totally nailed up online system which required lease lines, very, very expensive. And what we were offering was a distributed system, which is now commonplace, but was very, very unusual in those days. And the NAO and the PAC both acknowledged that that was an advantage. It didn't show up necessarily in the gradations of us versus our competitors at the time. But both the NAO report and the PAC review made the point that actually this distributed system, which was kind of a halfway house, of being mostly offline, but it could also go online as and when verification was needed, was a good approach.
You tell us in your witness statement, it's paragraph 46 for the cross-reference, that the withdrawal of the benefits agency from the programme increased the pressure on Post Office Counters Limited to move fast, move at speed.
Yeah, I did say that, yes.
Was there, you speak about an increase of pressure to move fast. Firstly, was there already pressure on the Post Office to move fast in the development and implementation of the programme?
There was. I mean, there was an imperative on all three parties. I would say that in ranked terms, the benefits agency wanted the fraud reductions and were instructed to secure the fraud instructions by HM government. And this was the best way to do that. So there was that political imperative on them. The Post Office wanted to automate for other clients, not just the benefits agency, to improve their competitiveness. And they also recognized that the benefit payment card, as it was conceived, was going to be their way of securing the maximum footfall, as you said, of benefits agency business.
Because it brings people into the branch.
It brings people into the branch, and when they're there, they buy other things, exactly.
So there was already pressure on Post Office Counters Limited to move fast. Where did that existing pressure come from?
Well, as I said in my statement, it was there for the reasons I just said. Their own business case relied on attracting new business and certainly maximizing the amount of BA business. There was a recognition that the BA business would go down over time because of ACT. Sorry, that's bank-to-bank transfers. So instead of someone going into the post office, they would get a payment through the bank.
Automated credit.
Automated credit transfer. So there was that trend in any event, and that was plainly what the DSS would have preferred. Because it's cheaper and it absolutely eliminates encashment fraud. It's easier to administer. So I would say that was always their preference. So the POCL wanted to head that off, that trend off, and get the thing automated as soon as possible. But so long as they had the benefits agency book business and ACT was on the back burner, actually the incentive on them was not as great as subsequently when BA said, okay, we are now going to go to ACT as our mainstream way of delivering, of paying benefits.
So why did the withdrawal of the benefits agency from the programme increase that existing pressure to move fast?
Because when they did withdraw, they said, okay, we're now going to go ACT, mainstream, and we're going to move away from the post office. And we're going to do that from memory, 2003. So they basically gave a window of opportunities to the post office to get themselves automated, and also something called network banking, which I assume we'll come on to later,
Yes.
Or universal bank in place before the default of moving everybody to ACT kicked in 2003. So there was a window from 1999 to 2003.
And how do you know this, that the withdrawal of the benefits agency increased the pressure, the existing pressure, on Post Office Counters Limited to move fast for the implementation and rollout of the programme?
Because of what I just said, which was written down in the exit agreement of the BA from the tripartite setup.
Do you think there was a risk that this rush to move fast was detrimental to the interests of sub-postmasters?
Well, firstly, I really can't comment on that detrimentally. Yeah, okay. Did it induce them to go faster than they should have done to deliver a safe system? There was pressure. Absolutely, there was pressure. But then again, we had an agreed rollout plan, which was not accelerated. In fact, it went backwards because there were issues, and they needed to be fixed. So from the time that the BA withdrew, I would say that there was at least a 3-month slip from what had been contemplated when they withdrew. And when we signed the heads of agreement with the post office, which then led to the codified agreement. So I think PSL, the people I dealt with, were very measured and careful. And I don't think that they cut corners. No, I don't think so.
So there wasn't, in the need to move quickly, the rush to roll out, any detrimental effect on the quality of the system that was delivered?
There were, again, I find it there's always a bit of a trade-off, at one level, you can only do so much in a test environment. This is a very complex technical system. And a lot of the issues that were experienced were operational, where things had gone not according to plan for some reason. I'm sure you'll delve into that later. But so you can do so much in a test environment, and we had massive amounts of end-to-end testing. There were also issues going across boundaries between the pathway piece and POCL, TIP and so on. So at some point you do actually have to go into the live environment and get feedback. The question for me is, what do you do when you get the feedback, and how well do you respond from that to that feedback?
Can we move to a new topic? We're going to come and circle back round a little later today to look at some of the answers that you've just given by reference to what in fact happened on the ground. Can you explain to the inquiry, in your own words, what the Pinnacle system was?
Basically, it was an error fault logging system. So if something had been reported to the help desk that indicated an underlying fault, then it would result in a pinnacle. A pinnacle would be raised, and that would go through the support and development team in order to get either a workaround or a clarification or a fix, a bug fix.
It's right, isn't it, that Pinnacle was an internal ICL system?
It was an internal ICL system, but POCL were aware of it and had visibility of it.
I'm going to test in a moment what aware of it and visibility of it mean.
Okay.
It was an internal system in that it was designed by ICL Pathway.
By ICL. It was a standard ICL system which ICL Pathway used.
Okay, so it was off the shelf, as it were, i.e. a pre-existing system that existed even before Pathway was conceived.
My understanding, and again I'm going back a long way, is that this was the standard that ICL used right across its business.
Can you recall who designed it?
No. No, I mean, it was pre-existing, is my recollection. We simply adopted it as part of ICL.
And you wouldn't be able to help us with who developed it?
No idea, sorry. As I say, it was pre-existing. It probably existed for years prior to the creation of ICL Pathway.
And in terms of running or operating it, that was done by ICL Pathway, is that right? In the context we're speaking about?
In the context we're speaking about, yes. All the data that went into it, the entries that went into it, and the outputs that came out of it were managed by ICL Pathway. Correct.
Can I turn to whether Post Office Counter Limited staff had direct access to the Pinnacle system? You tell us in paragraph 160 of your statement. I think we should probably turn that up. Page 53 of your witness statement. That's WITN 03770100 at page 53. And 160 at the bottom, please. Thank you. If you just scroll up a little bit, please. This is under the cross-heading Post Office Counter Limited awareness of issues within the Horizon system at the time of rollout. And you're dealing with a different issue here, but in the course of dealing with it, you say in paragraph 160, second line, my understanding is that Post Office Counter Limited had access to our Pinnacle system and test data, and that under the aegis of the joint acceptance incident workshop, they were intimately involved in the acceptance incident rectification plans, etc. It's the part of the sentence that says, my understanding is that Post Office Counters Limited had access to our Pinnacle system that I want to ask about. Are you there intending to refer to a contractual right vested in Post Office Counters Limited to obtain access to data held on Pinnacle, i.e. a theoretical right in a contract that could be exercised on demand by Post Office Counters Limited?
I don't recall ever having discussed that. My understanding was that certainly with respect to the AIs, all of the relevant Pinnacles were shared with POCL. So we had a lead on both sides, and they shared information between them.
Putting the AIs to one side at the moment, I'm looking at the Pinnacle system.
Right.
Are you referring there to what I've described as a theoretical right, a contractual right on demand? Can we please see what is on a Pinnacle? Or are you referring to an understanding that, as a matter of fact, the Post Office had direct physical access to Pinnacles just as a matter of course?
I think not as a matter of course. So in hindsight, I probably would have worded this slightly differently. The point here was specific to the AIs, and those Pinnacles that related to the AIs, I believe, were shared. That's different, I can see that, from having a contractual right to just go through any and all pinnacles. I don't know, to be honest, whether they did have access or some members of their team had access. I genuinely don't know that.
Are you aware of any policy or procedure or protocol concerning the issue of access by the post office to pinnacles and test data?
I don't know.
And so although this is written in an unqualified way, i.e. it isn't restricted to those pinnacles that were associated with AIs, albeit you're discussing AIs at the time, you don't have any evidential basis for saying that Post Office had, as a matter of course, direct access to all and any pinnacles. Is that right?
That is correct, yeah. I mean, this was written in the context of the AIs, and I can see that what I said there is probably too broad a sweep. I was thinking specifically of those pinnacles that related to the AIs.
And in relation to the AIs, what is your understanding of how Post Office Counters Limited secured access to those pinnacles that were associated with an AI?
To be honest, I don't know. You'd have to ask my technical colleagues. But
we'll get to those in due
okay,
course.
fine.
Can we look at the documents to see whether Post Office Counters did have a contractual right to look at records in pinnacles, so data that happened to be in pinnacles? And could we look, please, at Fujitsu, I think 6071. The codified agreement. And can we turn to page 49, please? And can we look at paragraph 801.2? I'll read it out. The contractor shall grant or procure the grant to POCL, any statutory or regulatory auditors of POCL and their respective authorised agents, the right of reasonable access to the records, and shall provide all reasonable assistance at all times for 6 years after the creation of the relevant records for the purposes of carrying out an audit of the contractor's compliance with this codified agreement, including all activities, charges, performance, security and integrity in connection therewith. Each party shall bear its own expenses incurred pursuant to this clause. On termination, the contractor shall, within a reasonable time to be agreed by the parties, transfer the records to POCL or a replacement contractor as instructed by POCL. The contractor shall thereafter be released from any further liabilities under this clause in relation to such records. You'll see that records in the third line has a capital R. It's a defined term. Can we look at page 89, please, of the document? I think it might in fact be the previous page. The previous page. If you could just keep going, thank you. Records, it defined in full and accurate records relating to the performance of the POCL services. I'm not going to turn it up now and chase down what POCL services meant, but it is defined in this codified agreement as the core system services and all other obligations of the contractor under the codified agreement. Can we go back to page 49 and paragraph 801.2, please? Thank you. This tends to suggest that Pockle had a right of reasonable access to the records as we've defined them, but for the purposes of an audit, if we just scroll up on the page, it's under the heading Audit. Would you agree, reading those now, that the primary purpose of the provision appears to be to allow access to the records for the purposes of a financial audit?
Well, that would be the normal implication of statutory, regulatory, and auditors, and keeping records for 6 or 7 years would be norm.
So you've got the heading, you've got the time period, and then you've got the reference to statutory or regulatory auditors pointing in the direction that the purpose of this clause was to give Pockle a right of reasonable access for that purpose.
Well, that's how I would have read it. You've just pointed me to the definition of records, which is broader than that. What I can say with confidence is that certainly at the time of the AI exercise, which I was very much involved in as joint chair with Keith Baines, I was confident that any and all pinnacles that were relevant were being shared. Now, what I don't know is whether our POCL colleagues were given direct access into the Pinnacle system. That's what I don't know. So there's the point about reasonable access and what is reasonable access. I genuinely don't know the answer to that. You'd have to ask a technical support person.
That's what I'm seeking to explore with you at the moment. Would you read these clauses as permitting Post Office Counters Limited access, because they're sufficiently broad, to allow access to records and give a right of access to records held within the Pinnacle system as a matter of course?
From the definition of records that you reminded me of, I think it's a reasonable interpretation. But what I would say is that I have no recollection of it being brought up as a contractual matter by Keith Baines or anybody else. It was never an issue, to my recollection. So either they had the access, and that would explain why there was no issue, or alternatively, POCL thought they had sufficient sharing of information without direct access, such that it wasn't an issue for them.
In terms of physical access, was that can be taken down, thank you. In terms of the situation on the ground rather than the contractual rights, on what system was Pinnacle run, or was the system itself called Pinnacle?
My recollection, and this was not really my bailiwick, is that this was a part of their support suite of applications that we, if you like, adopted from the mothership. I really don't know the answer to your question.
And were clients habitually given access to suites of applications provided by the mothership?
No. I mean, you need to consider security, and I would say almost certainly not. They were intended as internal systems. And normally, if we're carrying out a project for a client, on an outsourced basis or project basis, I would have thought that there would be an agreement about what information would be shared, but that wouldn't extend to direct access into internal systems. That would be my guess.
You looked in the course of your joint chairmanship of the resolution of some particularly complex and problematic AIs at Pinnacles back in the day on a relatively regular basis.
Yes.
Did you ever see an entry on a Pinnacle made by an employee of Post Office Counters Limited?
Not a direct entry. What I have seen is a reference to an individual in POCL support team who had, quote-unquote, authorized closure of a particular Pinnacle. And there were at least 2, possibly 3 of those that I have seen, and I referred to in my witness statement.
We're going to come to those in a moment. But you're not referring there to something that a Post Office Counters Limited employee typed in. This is something that an ICL Pathway employee typed in, saying,
Yes.
I've spoken to Mr. X or Miss X. They authorize closure, for example.
Correct. To repeat, this was an internal system, and we gave, I believe, reasonable access to it or extracts from it. But beyond that, we didn't allow POCL people to make direct entries and take control over it, no.
You said in my view, we gave them reasonable access to it. Did that mean, coming back to some of the answers you gave earlier, you still believe that they had viewing rights of it?
I don't know.
That they exercised?
I don't know whether they had direct viewing rights. I'll be, honest, I'm not sure I ever knew, and I certainly can't remember. What I would say is they had extracts, at least, which appeared to satisfy them at the time. But again, you would need to talk to my technical colleagues who had the direct interaction between themselves and their opposite numbers.
Can we look at some of the documents that you were just referring to? And a convenient way of doing that will be through your witness statement, because you actually cut into your witness statement the relevant Pinnacles.
Okay.
It's witness 0377 0100, and it's at page 41. And just to introduce some context, paragraph 122, you say, to understand better what had been going on in the run-up to the joint decision to start volume rollout in January 2000. In preparing this statement, I went through the Pinnacles raised in late 1999 that related to AI 376. I do not recall having seen any of these Pinnacles at the time, although, as explained above, I had been briefed on the issue. And then you set out in paragraph 123 3 Pinnacles, those ending 552, 884 and 363. You say that they are examples of Pinnacles that identified reference data as the cause of issues. The records show that in each case, Post Office Counters Limited were aware of what had happened and approved the closure of the Pinnacle as demonstrated by the quotations below. And you deal firstly with 552. And I think we've got the whole of the relevant bits of the Pinnacle there. It reads, this is clearly the result of the missing primary mappings on the local travel ticket products in the South End area. The error in the reference data was corrected on Friday the 24th of September, and therefore transferred transactions recorded up to that time, cash accounting periods 26 and 27, will fail to report to the cash account, causing a receipts and payments condition. And then this, okay to close as per Martin box of POCL 16/2/2000. And is it that last entry under your last bullet point there that you're referring to in your present answers when you say that it's clear that Post Office Counters Limited had knowledge of what was on some of the pinnacles because they authorised closure of them, and this is a record of an authorisation to close.
That's part of what I was trying to describe. This is clearly a little bit later than the actual AI workshops, which took place in August, September 99. So this being dated closure in February 2000. So this would have been an operational pinnacle that occurred. At the time, there were different pinnacles. There had been reference data related pinnacles that as I recall, the first known one was in June 99. So earlier I was referring to the approach during the AI workshops, where we had very strong focus on identifying the problems, understanding the root cause, and fixing them.
If we look at the next one, please, at paragraph 123.2, if we just scroll down. Thank you. Yes, that's got all of it on there. Again, the first three bullet points don't matter, but it's the fourth, for present purposes, okay to close as per Martin Box of Pockle. He was a Post Office Counters employee, Martin Box. And so this is a record made by an ICL Pathway employee of their claim that Mr. Box had authorised closure of the pinnacle. Yes?
That's my understanding, yes.
Now, of course, that wouldn't be necessary to make a record like that if Post Office Counters did have direct access to the pinnacle, because they could type in,
they didn't have,
we agree, closure.
can I just challenge you a little bit on that? They might have had view access, they might have had, but not write access. They definitely did not have write access.
And by write access, you mean writing access?
Writing access, yes. I'm very, very confident of that, but I don't know whether some individuals may have been given a viewing access. I just don't know.
So is your final position on this then, you don't know one way or the other, and we can get
In terms of viewing,
yes,
that's correct. I do know that they wouldn't have had write access.
Thank you. Can we look at, that can come down, thank you, at something which is the reverse of, or to some extent the reverse or the obverse of what we've just been looking at, namely remote access by ICL Pathway to systems to make changes to them at a counter level without the relevant sub-postmaster's knowledge and without the relevant sub-postmaster's permission. To your knowledge, did Pathway have the ability to obtain such remote access without the relevant sub-postmaster's knowledge or permission?
No. Let me give you a little bit of perhaps a longer explanation than you want. The way the architecture works was that all transactions, all messages, so-called, were exchanged between counters within a branch and then from the branch to so-called correspondence service. Mm-hmm. So they were all supposed to be in sync. Now, there was no ability to get access into a branch PC, but what there was a possibility to get into the correspondence server, make an entry in the correspondence server, which would then propagate back to the branch. So the effect would be the same. The point, though, is that it would be clear, should have been clear, I'd understood, that any entries made in the correspondence server would show up as entries made in the correspondence server. In other words, they would appear as a different counter or some such. There would be a marker in the audit trail that showed that those entries had been made centrally as opposed to within the branch. So if there's an argument later, the audit trail would have shown where an additional message would have been inserted. And that, for me, was absolutely fundamental, that there would be an audit trail. The other point I quickly make is that no message that had been created in a branch could be amended as that message was unique and discrete, a bit like blockchain. Riposte was a forerunner to blockchain.
When did you acquire the knowledge that you have just summarised?
At the time, I dealt with riposte technology to the level, as I was saying earlier, that I needed to in order to understand what could happen, what the risks were. And I also managed the contract with Escher, who were the supplier of riposte. And it was riposte that was at the heart of what I just described.
And so, to be clear, there was remote access by ICL to the correspondence server, which such access would have the effect, or could have the effect, of changing transactions conducted at branch level. But your understanding was that should be identifiable for audit purposes.
If I may slightly modify what you stated, the correspondence servers sat in Wigan and Bootle, so
Yes.
they were central servers. Secondly, they would show up with a timestamp as subsequent messages, well after the original. Let's say there was an erroneous message, some kind of doubling up or whatever. There were, Desi will go into that later, opportunities for error, let's put it that way, inadvertently, to occur, and this would have been a way to fix those after I would have expected a help desk call from the postmaster to say he had a problem. There was also this notion of repaired cash accounts and so on and so on. There's strict rules about that. But they would have all been made in the central service, and there would have been, as I say, a separate, completely separate set of messages associated with those changes, so that if there was an argument later, the audit trail would have shown that.
You said that separation and the separate set of messages was fundamental. Why was it fundamental?
Well, for actually the reasons that we're having to discuss, so that there would be no argument later.
No
Now,
argument about what?
Well, who had made what changes, who had made what errors. The
I.e.
idea was
whether
that
they were the responsibility of a sub-postmaster or as a consequence of action taken by an ICL employee at or in the correspondence layer.
precisely.
What controls and safeguards were that system, the use of remote access to the correspondence layer, subject to?
Well, you would have, I'm sorry to defer on this, you'd have to talk to my support colleagues. My understanding from, if you like, my commercial role was that there would be very stringent security controls, access controls for, I think I was expecting third line only, third line support.
Yes. And when you say stringent access controls, you mean the barriers or gateways that would have to be passed through in order to
Yes.
obtain access?
Correct. And the other thing I'd say on top of that is that, I'm sure you'll come on to this later, the third supplemental agreement and related service control documents stipulated very clearly that whenever anybody in ICL made a change, they were to inform POCL, or POL as it became, of whatever those changes were and the reasons for those changes.
How widely known at board level, ICL pathway board level, was it known that such remote access existed?
I don't know, to be honest.
Was it the kind of thing that...
Let me
Sorry.
carry on, try and answer that. did we ever talk about it? I don't remember a minute of it at any of the board meetings. But what I can say is that any system, you have to have some kind of third line ability to get into systems to make changes. Now, you want those to be as limited as possible, but there is that need. If there's a corruption, sometimes you just have to go in and fix it. Now, this is beyond my knowledge, that you'd need to talk to support people on just what they knew and how they actually did it in practice is the other point.
In terms of the breadth of knowledge at board level, which is what I'm interested in at the moment, was this kind of was this facility so obvious that it needn't be discussed?
Yes, because as I said, any system and all systems, I would contend, have very tightly controlled, they should be very tightly controlled, very limited number of key personnel, sorry, not key personnel in the sense of this contract, but trusted people with particular levels of expertise who could go and do a very limited number of amendments which would then be documented. And I stress that they should always be documented.
And when you say documented, do you mean separately written up and catalogued, or do you mean by the very operation of the system, there is an audit trail available of the messages?
There would be an audit trail of the messages. One would obviously need to go and look for them, and to know to go and look for them, which may have been a problem here, I don't know. But also the process around the third supplemental agreement was that whenever such a change was made, POCL were to be informed.
Would have been how?
Oh, there was again, if you were to refer to, I think it was called a TIP incident process, TIP reconciliation and incident process.
We're going to come to that in detail later.
Okay,
That's
but that's the place which would have defined.
That's a very specific issue arising out of a specific problem, AI 376.
Yeah, but this is all to do with, as far as I'm concerned, 376.
So
And
the answers that you've been giving are only framed by reference to AI 376, is that right?
Well, did you say you wanted to get back to it in detail later?
Yes.
My answer is in response to 376 broadly. Maybe when we get to it, you'll see if it needs to be expanded on. But that's the context I'm referring to. Yes.
To your knowledge, did anyone within Post Office Counters Limited know about ICL's remote access to the correspondence layer?
It was a requirement in the supplemental agreement, so yes. I mean, you say remote access to the correspondence layer. This was support people who, in a sense, logically sat right on top of the correspondence server. So the remote point, I don't quite fathom. They're logically sitting in the data center managing these correspondence servers.
We could knock off the word remote and just say access.
Yes.
Can I turn, in fact, before we turn to the next topic, I wonder whether that's a convenient moment, sir, for the morning break.
Yes, by all means. Yeah.
So could we say past, please?
Yeah. Fine. Thanks very much.
Thank you very much. So good morning. Can you see and hear me?
Yes, I can. Thank you.
Thank you, and likewise. Mr. Oppenheim, can I turn to consider disclosure obligations for the purposes of criminal proceedings?
Mm-hmm.
After the Benefits Agency withdrew from the tripartite arrangement, we know that ICL, Pathway and Post Office Counters Limited entered a bilateral agreement.
Yes.
I just want to look, please, at paragraph 277 of your witness statement. That's page 85, please. It's in fact the last paragraph of your statement. I hope by now, if we go down, thank you, the page has been replaced and you can now see your signature in there.
Yes,
That is your signature.
that is my signature.
The GRO, the General Restriction Order Redaction, has been
Yep.
removed. But anyway, more substantively, at paragraph 277, you say, I was aware of Post Office Counters Limited, excuse me, facility to mount private prosecutions against sub-postmasters determined to be acting fraudulently, and that the codified agreement, just interposing there, the codified agreement is the agreement that I just mentioned, required pathway to provide audit trails when requested to do so to support such prosecutions. My expectation was that each case would be properly investigated before concluding that the cause of a cash shortfall was indeed fraud rather than some kind of mismatch in the system. To the best of my recollection, I was never asked to look into any of these cases. Indeed, I was completely unaware at the time that the prosecutions were going on. It's the first sentence that I'm interested in particular. You were aware, that's aware at the time, of Post Office's facility to mount private prosecutions against sub-postmasters.
I was. There's a provision in the contract, and there was in the original POCL contract, which was the forerunner to the codified agreement, it just carried forward, that we would support the Post Office in, when requested to do so, in mounting such prosecutions, with the provision of information.
You referred to the codified agreement, which we're going to come to in a second, and the fact that it was carried forward from the original agreement to a provision. Is it through that means, by that means, that you knew about the facility of the Post Office to bring private prosecutions?
That was the original trigger for that awareness, and I remember asking Liam Foley, one of the colleagues who will remember, from the organogram, about it, and he explained that that did exist. I was very surprised at the time.
Surprised about what?
That the Post Office had that jurisdiction.
And why were you surprised?
Previously, I was just unaware that anybody had that jurisdiction other than Crown prosecution.
And so the awareness that you had existed in the period from, would this be right, about 96 to 2002?
That sounds right, yes.
And so you knew that it was the Post Office, unusually, who would be a prosecutor rather than, as you said, the police or the Crown Prosecution Service.
As I say, I was aware of it. It never really came up in my working experience over that time.
Can we look at the second part of the sentence there, where you are, is this right, drawing a link between your knowledge of the facility of Post Office to prosecute in the criminal courts, its sub-postmasters for fraud, and a part of the codified agreement that requires the provision of data to support such prosecutions?
Yeah, I'm trying to make the case that the point that I was aware of the provision to provide such information, and I assumed that it would be a rare thing when it happened, and that we would provide the audit trail kind of information that I was referring to earlier.
Why did you assume that it would be a rare thing?
Because I had assumed that inspection of the kind of information that, again, I referred to earlier, whereby we where there was a mismatch in the system, as referred to here, and in the third supplemental agreement in particular, and the subsequent operational processes, there was an acknowledgement that there would be occasional mismatches. I mean, everybody knew that. And the scale of the system was such, any remote system will have mismatches occasionally. So the question then was, well, what happens when there is such an event? And my presumption was, wrongly, that Post Office would look into those and certainly at the outset, as I say somewhere else, give the postmaster the benefit of the doubt. We needed feedback when these things occurred in order to find the errors in the system and then and fix them.
Why would you assume that the Post Office would give, in prosecutorial decisions, sub-postmasters the benefit of the doubt?
Well, I'd assumed that before getting to prosecution, the people that were on, as it were, the other side of the fence from me would look into the evidence, the audit trails that we were talking about earlier. So it would start with the support people, and they would look at it, and they would put questions to ICL Pathway, and we would respond, and we would dig into these things in the same way as we did with Pinnacles. That was the whole point about Pinnacles, and incidents, and also problems, which were combinations of similar incidents.
You said that you assumed. Is that something that you remember assuming from 25, 27 years ago, or is it something that you've looked at now and is a ex post facto rationalisation of what you think you would have thought had you thought about it at the time?
It didn't occur to me that POCL would rush to prosecution without checking the facts. And the fact that we had all of these very, very detailed provisions as to what to do under certain error conditions, operational error conditions, for me was an indication that my opposite numbers understood that these things would occur and that there was a process for dealing with them. And that on occasion, I write somewhere, there's a specific statement in third supplemental agreement that it would not always be possible to determine what exactly had gone wrong in a particular case. And therefore, if we had to make an assumption about putting something right, we would absolutely inform the Post Office of what that was, and then it was up to them to determine whether that was a correct assumption or not. I was very uncomfortable with the pressure that we were under to actually make corrections. We were invited to make all the corrections. We pushed back on that, and in the case of tip errors, the Post Office then made the errors, the error corrections. But there was just a general understanding between all the technical and commercial people that there would be occasional errors. There's something like 10 million transactions a day going through the system. There will be errors.
And it's, you either think now that you would have thought had you addressed your mind to it, or thought then that the Post Office, in making prosecutorial decisions, would, against that context of the likelihood of errors generated by the system itself, have given sub-postmasters the benefit of the doubt?
Benefit of the doubt, it's certainly in the early stages when you always have teething problems with any new system. So you asked earlier about, did they rush to roll out? Did we rush to roll out? There was a judgment call made as to the quality. We passed the tests. But the word of caution was always be on the lookout for new things that we didn't know about. And that's the same with the introduction of any new, large, complex system. So in the early days, certainly, I would have said, let's listen to the feedback, pay attention, work out what's going on here, and in that circumstance, yes, give the benefit of the doubt. I'm not sure what that would necessarily be what I would have said, say, 5 years in, when the thing should have been completely bedded in. But even there, it needed to be an inspection of the audit trails and the facts.
We can take that document down, but in its place, please put Fujitsu, I think 6071. back to the codified agreement. Can we look, please, at page 97? And if we can highlight, blow up prosecution support 418 and 419, please. These provisions in the codified agreement provide that the contractor shall ensure that all relevant information produced by the POCL service infrastructure at the request of POCL shall be evidentially admissible and capable of certification in accordance with the Police and Criminal Evidence Act 1984, the Police and Criminal Evidence Northern Ireland Order 1989, and equivalent legislation covering Scotland. At the direction of POCL, audit trail and other information necessary to support live investigation and prosecutions shall be retained for the duration of the investigation and prosecution, irrespective of the normal retention period of that information. Would you agree that in order for ICL Pathway to comply with these provisions, it would be necessary for it to understand what is required in order to make information evidentially admissible and capable of certification in England and Wales in accordance with the Police and Criminal Evidence Act 1984?
That's the requirement as stated, yes.
Well, it's the requirement as stated, but in order for compliance to occur, it would be necessary for your company to understand what is required in order to ensure that such relevant information is evidentially admissible. How do we go about carrying that provision into effect?
Absolutely right. That's what is required of us, and that's what we should have done. Now, what I can't speak to is personal knowledge of those details. They're very important details, but I was not involved in that. That whole area was, as I recall, Martin Bennett, risk management, part of his portfolio.
But would you agree that ICL Pathway would only be able to comply with the provision if it knew what the requirements of the law were, so that it could ensure that data was captured, retained, and enjoyed sufficient integrity and reliability, and be placed in a suitable form evidentially to a court?
So my understanding was, I never looked at this in detail, this provision in detail myself, but my understanding was that the information provision that was agreed between ICL Pathway and POCL, specifically around the third supplemental agreement and the related control documents, were designed to deliver precisely this. And there was a mass, as I was alluding to earlier, a mass of audit trail information behind that. So out of all of that, I would have expected all of the substance to be satisfied. What I don't know about is the form and the detail of those requirements.
You said in the middle of that answer that you didn't, I think, concentrate on this requirement in detail at the time. You did tell us in your witness statement that you were aware that the codified agreement required Pathway to provide audit trails when requested to do so to support private prosecutions.
Correct. I was aware of these two paragraphs.
Being aware of those two paragraphs, to your knowledge, did ICL Pathway seek advice on what the requirements that had been placed upon it were in order to be able to achieve compliance with the contractual provisions?
I have to say I don't know. I covered a lot of ground, but I didn't cover this ground. This was, as I recall, as I said before, the remit of Martin Bennett. Whether he took external advice or not, I'm afraid I can't tell you.
Would you agree that in the absence of either such advice or a very good existing understanding of the criminal law, which is perhaps unlikely within IT professionals, compliance with the clause at a practical level would be difficult to achieve?
I don't know. It's, if all of the basic data was good data, was kept and was made available, then I should have thought that that was what this was pointing to. But I don't know.
Well, for example, you wouldn't, unless you knew what the law required, either because you knew it or you've been advised about it, you wouldn't build into your systems a requirement or a process which says if a client ever wishes to use the data which our system is producing or handling for the purposes of criminal proceedings, then we would have that data ready for disclosure and for such use in a state that's evidentially sound. You wouldn't design your systems that way.
You wouldn't necessarily make any changes to the design of the system, which was designed to flag issues and, to the extent possible, identify the root causes and the appropriate courses of action and report on them in a day-to-day operational sense. So if it satisfies those, and it satisfied the Post Office requirements, very detailed indeed about reporting, then I should have thought that their requirements at the CCD level, contract control document level, would have encompassed this, because they were the people who were basically the custodian of this process for the Post Office.
And
if they weren't satisfied with what we were doing, I would have expected them to have told us that. And if they had looked at it and felt it was wanting, then it would have come to me as a contractual issue. But it didn't.
One approach would be to say, look, we know or we've been advised that at this time the criminal law, a provision in the Police and Criminal Evidence Act 1984, says that it may be necessary for an employee of Pathway to say to a court, there are no reasonable grounds for believing that the data produced by our system is inaccurate by improper use of it. How are we going to be able to say that in a witness statement to a court? Can we design our system in a way that allows an ICL Pathway employee to say such a thing?
So taking your question in the two parts, taking the second part first, the design of the system was first and foremost to ensure accuracy, but also then operationally, if there was an error identified, identify the error, identify the root cause where possible, what fixes would be needed, and the processes for managing that all through and reporting on it. So that if it satisfied those, then I can't imagine, apart from presentation, that there would be anything more that we would need to do to satisfy this condition. But that statement is a statement out of not knowing the detail of the law. Now, as I said, Martin Bennett would have had this responsibility. There were people in probably second or third line support who would have been charged with pulling out the audit trails and producing the evidence. We also at the time had an in-house lawyer. He may or may not have looked at it.
And what was his name?
Warren Spencer. You may recall him from the organogram. So what I don't know is whether my colleagues looked into this at that sort of legal level and satisfied themselves that based on the operational data that we would be producing, that we would be compliant. Now, as for getting one of our people to talk to the accuracy, and I would always hope that there'd be a degree of caution inserted in any statement that can guarantee that this is accurate. Because with IT systems, sometimes they do go wrong. That's just the nature of them, particularly, as I said, where they're distributed. You have breaks in communication between the branch and the center. You can have a printer fail in the middle of a transaction. There are all manner of things, or run out of paper in the middle of a transaction, all manner of things that can go wrong. And if they can, then they will, particularly at such a large scale. So you've got to allow for the possibility that something's gone wrong that we don't actually understand.
You said that Martin Bennett had responsibility for ensuring the discharge of this obligation.
I thought so. This would logically have come under him. Alternatively, it would have come
Just
under
stopping you there, we can take that down from the screen now.
Alternatively, it would have fallen to my service director colleague, Steve Muckow, at the time. So it could have simply been given to him to enact. But in terms of satisfying ourselves that we could satisfy this, I would have expected that to have been Martin Bennett and possibly Warren Spencer.
Why would you expect it to have fallen to Martin Bennett?
Because this was viewed as, I think, to the extent I recall it at all, a risk item. But it could also have been a support item, which would have made it Stephen Muckow. So I genuinely don't know.
Why would it have been viewed as a risk item?
Because risk was his title, but he was also head of assurance, audit, and the like. So this would have come under his other responsibilities to do with audit.
Who, if anyone, would have been the liaison point within Post Office Counters Limited in relation to this issue, the design of a system or the enactment of policies that carry this high-level statement into practical effect?
I'm afraid I don't know. And it's possible that it was missed at the outset until it started to happen. I mean, I just do not recall this ever having come across my desk. Sorry.
Are you aware of any policy protocol or other document that does in fact carry this contractual obligation into effect at a practical level?
No. As I said, there were lots of service, incident, problem management and such like documents which talked about what you do when something goes wrong, but not in regard to this, no.
Yes, there are many, many documents that deal with the operation of the system and the rectification of errors within it at an operational level, as you rightly described it. I'm not looking at this through an operational lens.
I understand.
I'm looking at it through the lens of a contractual provision that says you've got to be ready to disclose things in a form effectively that's evidentially secure for the purposes of the criminal law.
So secure in that context for me would mean it has integrity, it's accurate, and it's complete. And whether that is, those are requirements in any event under the contract, as far as I'm concerned. So there was nothing that I thought at the time, benefit hindsight's a wonderful thing, that I needed to look at this provision specifically, because I felt that all the other things would, in a sense, provide the detail behind it.
Did you know Gareth Jenkins?
I know his name, and I don't recall actually ever having had dealings with him.
What did you understand at the time his role within ICL Pathway to have been?
I can't remember. He was not someone I can recall dealing with, and all the material I've gone through for to prepare for this session, I mean, his name has obviously come up in the context of these proceedings, but I don't recall his name being on any of the pinnacles or any of the AIs. So I wouldn't have dealt with him. He was in the support group, and I wouldn't have dealt with him. Sorry, development group.
Do you know why he was selected as a person to give evidence as a witness with expertise or as an expert witness on the Horizon system?
Well, bear in mind when I left the program, there were people like Terry Austin still there, senior people, more senior, as I understand it, than Gareth. But by the time a lot of this happened, I would have said, from what I've seen, that he was probably the most senior person and was therefore designated to act for ICL Pathway. But I don't know.
Are you aware of a practice where, in the course of a prosecution of a sub-postmaster for theft and or false accounting, a request was made for data by them about the operation of the Horizon system, and by then Fujitsu representatives asked for payment for producing the documents that the individual requested?
No, I'm not aware of that, and I would have said that was wrong.
Wrong because it would be in breach of the contractual obligation to provide the data or the evidence.
Well, wrong for that reason, and wrong morally as well, I've thought.
Can I turn to AI acceptance incident 376 and the cash account discrepancies issue? Can we look at this issue? And this forms a large part of the evidence in your witness statement, so I'm going to spend some time on it. Can we start firstly by explaining to those who don't know what an AI is?
An acceptance incident. So the codified agreement requires that we run a trial, a live trial, for a period of 3 months on 300 post offices, at the end of which there would be basically an acceptance review.
Just stopping there, because that language may be unfamiliar to non-IT professionals. An acceptance review.
Okay, so an acceptance review would be basically that POCL would have looked at the system, looked at the data, looked at basically everything that they could look at, and determine if it was working according to the specification or the requirements. So was it working properly, or were there defects? And if there were defects, then how serious were the defects? And there was a classification grid, if you will, of A, B, C severity defects. And we were allowed so many A's, so many B's, so many C's.
Yes.
In fact, we weren't allowed any A's, we were allowed up to 10 B's from memory.
0 A's, 10 B's.
10 B's. So basically it was a granular review of the performance of the system, as I say, across 300 post offices and 3-month trial period.
And so the acceptance in the phrase acceptance incident refers to acceptance by post office.
Acceptance by post office, correct. And an incident obviously means that something was wrong. It was an incident, a bit like an incident as it would be reported from again, an operational standpoint.
So with that helpful introduction, can we look, please, at AI 376? That is poll 3043691. And can we turn to page 56, please? sorry, 57. Thank you. I'm just going to spend a little time on this because this is the first time that the inquiry, I think, has seen an acceptance incident form. You can see in the top left-hand corner that it's described as an acceptance incident form. Yes?
Yes.
And then on the right-hand side, the acceptance incident number is included. This one is 376.
Yep.
And are those numbers generated by ICL?
You mean the incidents?
Yes.
They've been raised by TIP. TIP is POCL. So what would have happened there is ICL Pathway would have transferred data which would have come from the branches into the correspondence service, moved into our so-called TMS system, and from there transferred to TIP. And TIP would have compared, in this case, two sets of data, and would have identified that they were inconsistent with a cash account.
My question was much simpler, I think, was who attributes the number on the top right-hand side, 376?
Oh, I'm sorry. I think that was POCL. The acceptance incidents were, as I recall, recorded and flagged by POCL, and they led to the AI workshop that we were talking about.
How did they generate acceptance incidents, POCL?
I'm not absolutely sure. I mean, they would have identified, if you like, a bundle of similar problems, errors, like these, 821, 822, etc., etc. And they would have recognized that they were all of the same ilk, put them together. We might have called that a problem under normal operational conditions when you have similar things producing similar bad outcomes. So we'd look at that as a problem, and in this context, they were examples of this particular acceptance incident, which was designated 376, and we had 218 and others as well.
Hundreds of them, yes.
I'm not sure there were hundreds, but logically with 376, I suppose there must have been.
Yes. My question again was more basic. How did they physically generate a new acceptance incident? So not why would they do it,
I don't know.
or what would cause them to do it.
I don't know.
Would they pick up the phone and say, we've got a series of problems, they are as follows, please generate a new acceptance incident? Or could they create this form?
They would have created this form. Martin Box.
I'm sorry,
Sorry, they would have created this form. The facility was this form, which they would then fill in, as they have done here. Martin Box is the same Martin Box I recognise from that pinnacle that we talked about earlier.
So are you saying that Martin Box drafted the form?
No, we would have agreed the form between us. I can't remember who instigated it, whether it was them or us, probably POCL. And then they would have populated it, and then we would have responded to it.
Do you think that somebody from POCL could get into the system that maintained acceptance incident forms and write text into them?
Absolutely. This would have been their form, not our form.
So this is a POCL form, not a
Yes.
an ICL form.
Yeah. It was POCL who raised the acceptance incidents, and we had to deal with them. Correct.
So we'll see that the second box down on the left, the acceptance test name is TIP interface. What does that mean, acceptance test name?
Sorry, where is that?
Second box down on the left-hand side, underneath acceptance form, it says acceptance test name.
Yes,
Box
TIP
2.
interface, right. So this is what I was trying to describe before. So there's a daisy chain of data transfers.
Just stopping you there. I'm not asking about the TIP interface. I'm asking what an acceptance test name is.
Well, it simply identifies where the problem occurred.
Okay, so this is locating within,
Yes.
this box is locating in generic terms where in the system
Yes,
the problem exists.
exactly.
Source, box 3. So you see after all of the boxes, there's a number in parentheses. I'm going through them in order. I think each time you're diving down into box 10. I'm just taking it very slowly because you're our first witness on this. What does source mean?
Well, the person who would have spotted the problem. So this is, I think, POCL's business support management, I think.
And then the date observed, in this case, the 19th of July.
Yes?
Box 5, witness or reviewer who observed the incident, and you've said already that Martin Box was a POCL employee.
Yes?
Authority in box 6, what was that authority for or about?
I can't recall. I really don't know.
Box 7, the incident type. Can you tell us the difference between criterion not met and substantive fault?
You'd really...
I'm sorry.
I would say no, I can't. I could guess at it, but these were determined by POCL, not us. There would have been discussion about them, but there was very often something of a disagreement between us as to how severe a given AI was. I mean, there was some debate about that. It wasn't an acrimonious debate, but there was a debate. We would always obviously prefer something to be less serious, and they would sometimes argue that it's more serious than we really thought it was.
Why would you obviously want something to be less serious? Surely you wanted to do the accurate thing.
Absolutely right. But there was a question, if it had no impact on the integrity of the system, then it should be classed as a C category. And then it could be swept up, dealt with, and released in the next release. If it's an A, it's a showstopper. You can't go forward. You have to identify it and fix it as an emergency update, in effect, before doing anything else. If it's a B, it sits somewhere between the two. So you really need to determine the impact or potential impact of whatever it is that's been flagged as wrong.
You've already addressed box 9 on the right-hand side. Can we move to box 10, the description of the incident? And as this is our first AI, I'm going to read it as a whole. Description of incident, new description. AAI's contravention stroke data integrity, derived cache account not equal to the electronic cache account. Incidents, and then there are a series of tip numbers given, have been raised by tip in respect of all transactions that constitute a cache account have not been received by tip, or when electronic cache accounts received where transactions that have been conducted and received by tip are missing from the respective cache account lines. These issues have come to light when comparing a tip-derived cache account with the electronic cache accounts sent by Pathway. Not all instances of similar occurrences have been logged by tip, as the physical resource to check each occurrence of a difference within the derived versus the electronic is not available. It was expected that this facility would by now be comparing like with like. This is very significant. Missing transactions and missing cache account line entries cause reconciliation failures within POCL back-end systems, and error resolution is invoked. The cache account produced by the organizational unit in these instances must be in doubt and is not a fair reflection of the business undertaken at each organizational unit. A sub-postmaster may be asked to bring to account an error, but the error was produced via system failure rather than human failure. many hours of investigation at both the front end and back end have taken place to help resolve these problems. The benefits assigned to POCL back-end system in respect of an automated cash account are being questioned. So just looking at that text for the moment, you'll see that about 10 lines in, the author, whoever it was, says that the incident that they're describing is very significant. Would you agree with that?
Yes, I would.
And why would you agree that at this stage the incident was very significant?
Well, for all the reasons set out in that long paragraph, there's nothing I would disagree with in there.
It's very serious because what is described undermines not only the very purpose of the system, it means that the system lacks integrity, it lacks veracity, and it lacks reliability, doesn't it?
At that point, 19th of July, summarising things that had been found up to that point, yes. That position was untenable, and there's no way we could have gone on, and we didn't. You then need to look at what actually transpired after that.
We're going to spend the next two or so hours, I think, doing that.
Okay, fine. But yeah, this was a showstopper, and I would have had it down as substantive or whatever. This is a category A. I mean, there's no doubt about it.
And reading on in just after the sentence, this is very significant. The sentence, the cash account produced by the organisational unit in these instances must be in doubt, and it is not a fair reflection of the business undertaken at each organisational unit. That's one of the reasons why the issue is very significant, isn't it?
Well, it's one. It's also, it then goes on to talk about the impact on the branch and the sub-postmaster. So this is, as I said, an absolute showstopper. You've got to then look at actually what caused the problems and what was done about them.
Put in blunter language, that sentence means that it's not a fair reflection on the sub-postmaster because the system is showing a false balance.
It is. That's absolutely right, which is why this needed to be looked at in significant detail. We had only recently, this was summarised 19th of July, only recently really got going with interfacing with TIP on EPOS transactions. Most of the previous effort had been on the benefits agency up until June of 99. It'd been virtually all benefits agency, no EPOS transactions at all. So all of the 200, as they were, post offices running child benefit in the northeast and southwest were only doing child benefit and order book control. So this was new, and it was clearly a showstopper, as I said. The question was what was done about it, and where did we end up?
The next sentence, the cash account produced by the organisational unit, you've referred to the branch. That's another way of referring to the branch, yes?
That would be my interpretation. It's not a term I'm familiar with.
I'll read it as branch for the moment. The cash account produced by the branch in these instances must be undoubt, and it is not a fair reflection of the business undertaken at each branch. So and then a sub-postmaster may be asked to bring to account an error, but the error was produced via system failure rather than human failure. That sentence there, in a single sentence, describes one of the main issues being investigated now, doesn't it? The Horizon system created the balancing errors by the way that it operated, but suggested that the balancing error was that of a human and not a computer.
That was the case then. To what extent that continued to be the case after all of the remedial work, that would be for me the key thing. But at this stage, it's a bad indicator. I agree.
And although the wording of that sentence about accounting is perhaps a little opaque, would you agree that what is being suggested is that a sub-postmaster may be asked to account for an error, even though it was not his or her error?
Yes.
And would you understand that account for doesn't just mean provide an explanation for, it means in context paying for it or facing the consequences of not paying for it?
Yes. And I would simply add, and POCL knew that, which goes to my earlier remarks about their knowledge that there were, at this stage, unacceptable errors to the point where it shouldn't roll out, hence the AI process, and subsequently that there was still always going to be a risk that such a thing could occur, and it would need to be investigated.
Moving on, if we scroll down, please. Severity. POCL, high, would affect POCL's ability to produce an accurate cash account. So POCL are describing the severity of the incident as high. PWY, that's pathway. Pathway, except the problem exists, would argue about the severity. Would it genuinely affect the accounting integrity as it currently stands? Question mark. You've told us this morning that on the basis of the earlier text, this was a showstopper. The point was made the system untenable. It was a fundamental issue and was undoubtedly high. Do you know why Pathway are recorded as saying they would question the severity? And
I think
asking, would it genuinely affect accounting integrity?
So we're now going back 20 whatever years. I can't defend the proposition that it should be anything other than a major high severity fault. I think I can only assume that there was an assumption there wouldn't be very many of these. We've got pinnacles that were being fixed, and that when those had been fixed, we understood, in other words, the nature of the problem, and when they'd been fixed, that would resolve the problem. Now,
that's a different way of looking at it, isn't it?
Well, it's
as I think you know, Mr. Oppenheim, this isn't saying we can fix it in the future, or we're developing a fix for it, and therefore, when that takes effect, the severity might be downgraded. This is at the point of reporting saying that Pathway were questioning or arguing over the severity, isn't it?
All I can do is give you a view as to the way that my colleagues would have thought about this. So when Steve Warwick says, we understand this, we're on top of it, we've got to fix, or fixes in process, and there's a substantive software update in process that will deal with this. I can imagine they'd say, look, we're onto it, it's not going to be a problem, or not a serious problem. We think it's a medium-sized problem, and that would be my interpretation. But it was wrong to assert that, given the facts as they were at that point. I do agree with that.
Thank you. Moving on, it says rectification. Steve Warwick, he was an ICL employee.
Yeah, he led the development of the EPOS team.
To provide rectification of this issue. Pathway understand the problem and are currently working on the fix. Steve Warwick to provide details. Just stopping there at the moment and without looking forwards to what happened at the moment, would you agree that if you were a sub-postmaster accused of stealing thousands of pounds from the post office and you believed that you had not done so, and instead the Horizon system was faulty and was responsible for the imbalance shown, and you were before a criminal court, you would wish to know about this document here, wouldn't you?
What I'd say is I'm not sure who Pathway was in this instance. There are no names given other than at the bottom Steve Warwick. So I don't know who asserted that this argument about severity. And without knowing that, I can't really answer. I would say he was not representing Pathway, because when it came to the AIs, I represented Pathway, and we accepted that this was a high severity issue. So this was on the way to getting there. I'm not going to excuse it. I don't agree with it, but I don't know who it was who expressed this view. It would have been at a low level.
Putting the issue of the severity of the classification of severity to one side, but just looking at the document itself, if you were a sub-postmaster accused of stealing thousands or tens of thousands of pounds, and you believed that you hadn't done so, and that the system was responsible for the imbalance shown, you would want to know about this document here, wouldn't you?
Very likely you would. The point about the possibility of error goes to what I was saying earlier, that one would need to look in detail before mounting a prosecution at what had actually happened and what had actually gone wrong. This was very, very early, is the point I would emphasize. I don't agree with the proposition by whoever it was in Pathway that it would be low severity. I know you suggested it should be put to one side. But the point is that it triggered a massive amount of work subsequently on both Pathway's side and also Post Office's side, because one of the problems was, as you referred to earlier, was reference data. So reference data errors were the reason for quite a lot of these mistakes.
Can we move to box 11 and display a little bit more of that, please? We'll see that the box 11 has not been completed. It's a little difficult, for me at least, to understand who is supposed to complete what here. Under the first box, underneath signatures, witness stroke reviewer, from which organisation would you believe that the witness or reviewer would come in order to complete that box?
POCL.
The Horizon Acceptance Test Manager, from which organisation did that person come?
That would be Pathway, I think.
And then on the right-hand side, it's got Pathway. Do you know what or who was supposed to complete that box?
I don't. My guess is it would be the when we came to the AI resolutions, the person designated as lead for a given AI.
And then on the far right-hand side, AIM. Do you know what that refers to, and who would sign and date that box?
Sorry, no, I don't.
Underneath the dates, that is, the DSS Acceptance Manager. In July 1999, did the DSS Acceptance Manager have any role to perform?
No. So
Is that a relic?
This is a relic. This is a form that was devised prior to the DSS dropping out. Bear in mind this was dated July, and then it dropped out in May, June.
POCL Business Assurance on the right-hand side. Do you know who or what that refers to?
I can only assume that it was someone in POCL who was looking over the shoulder of the people we were dealing with.
And then lastly on this page, I think a date for entrance into an acceptance database. What was the acceptance database?
We had Excel spreadsheet which listed all the AIs, but I that's the only one I can think of. It was a database, and it tracks day by day every movement in the status. So I'm assuming that's what it would be.
So if in future any person, whether they are a prosecutor, a defence lawyer or a court, that wished to examine whether there were issues, to use a neutral term, with the reliability or integrity of the system in its design, implementation and rollout phases, could look at an acceptance database, for example, to see whether such issues were recorded there.
So the acceptance database, I know, dealt with the A's and B's, and there was reference to the C's, but I don't think it went into detail around the C's. At least it was a level of, if it did exist, probably did, it's not something that I ever focused on. But the A's and B's, definitely. And I think that's probably what we're concerned with here.
And so in answer to my question, there would be a ready catalogue of issues that such a person could look back on.
Yeah, certainly the formulation of, this is specifically the acceptance incident process, the workshop process, that was all very, very carefully documented, and I've seen in my review of the papers, I've seen examples of that. I think I got them from Fujitsu rather than yourselves, but I think I referred to them in my witness statement. If not, I can share them with you. They can.
Can we go to the second page of the AI, please? So scroll down. We can see in box 4, analysed incident severity, high, medium or low. That should be completed, shouldn't it?
It says in the second box, low. So
Yes. So this is read in the context of the page before, the reporting of the incident severity, and then this is after analysis. Is that right? Do you remember the previous page?
I'm just thinking, sorry. I think that must be logically the case.
And analysed by whom?
If this was Fujitsu's response, sorry, ICL Pathways response, which I assume it is, it looks like it, then does it have a name at the bottom? Would it be Steve Warwick?
No, the form. Well, there is a name at the bottom in some of the boxes of somebody called John Pope.
Okay, John Pope was the analyst who worked for John Dix, who you may recall from the organogram, and he was one of those charged with the resolution of these AIs. So he was somebody I worked closely with at the time, and he would have gone through with the Steve Warwicks of this world to determine what, the position was. He would have analysed the data.
Does it follow from the answers that you gave earlier that you would fundamentally disagree with the analysis that the severity of the incident was low?
I did say earlier, as I recall, that one would need to look at what happened subsequently, and this is what happened subsequently. I'm sorry I didn't remember. So here he's saying there's no suggestion or indication that there's a fault in the calculation or reporting of the cash account.
Just before we get to that, you're reading from box 6.
Yes, I am.
Let's read that together. Pathway has analysed all occurrences where the tipped-derived cash account does not equal the actual cash account. There is no suggestion or indication that there is a fault in the calculation or reporting of the cash account. The incidents relate to an occasional missing transaction when reporting to TIP. This had a rate of occurrence of around 1% of outlets per week, based on an analysis of the reported TIP incidents. It is agreed that this would have been unsustainably high when considered against the target population of 20,000 outlets, because that's about 200 a week, yes?
Yes.
The agent modification referred to in previous analyses has been operational since the 3rd of August and is operating successfully. An updated summary of TIP incidents was supplied on the 11th of August as actioned. As noted, the root problem has been diagnosed in all, quote, non-quote, serve customer, end quote, transactions, leaving one further problem under diagnosis relating to occasional scales transactions, which are all in serve customer mode and are corrected by the agent modification noted above. In addition, Pathway has established routine monitoring for all harvesting exceptions, and should any occur, will notify them to TIP in advance, and has agreed a suitable procedure with TIP, thereby substantially reducing the TIP effort in handling any exceptions. POCL has removed the aspect concerning the reference data change from core to non-core from this AI and re-raised it as AI 410. In this case, there is no fault within the Pathway system. Pathway has proposed an approach to POCL to avoid this problem through the use of product types within RD, within reference data. So, can you, to a naive audience, translate what perhaps Mr. Pope has written?
Okay, so going back to what was stated at the beginning, that was a very, a very unacceptable. It was an unacceptable position if confirmed. So if the cash accounts were going wrong, then that was unacceptable. What this is saying is that the cash accounts weren't going wrong, but there were problems with quote-unquote harvesting all the transactions and reporting them faithfully to TIP. And transactions are needed by TIP for them to reconcile with the post office, to reconcile with their clients. So it's very important that they all be complete. Why would some be missing? Because there was a problem with one of the agents. So an agent modification was put in place on 3rd of August. Now,
what's an agent modification?
An agent basically looks at the data in I think the correspondence server, or it could be the branch, I'm not 100% sure, and it pulls that data into the database, into TMS. TMS is Transaction Management System, which was ICL Pathways database that then transferred the data to TIP. So as I said, this is something of a daisy chain which operates remotely in a world before the internet, when dial-up modems were still, standard. So you had an ISDN link, had to get the data from the branch to the central data warehouses, and then make sure that they were converted into the format that TIP required. And we were operating to a draft specification for the TIP interface still at that stage, by the way. And TIP would sometimes struggle, let's say, with what was being sent across. Now, the agent is what sucks in all of that transaction data, and there had clearly been a problem which required a modification. The modification had been applied on the 3rd of the 8th, which wasn't that long after this AI had been raised.
19th of July.
19th of July. So, as it said at the bottom of the original paragraph, Steve Warwick's got a bug fix in process on this issue, which, as I said, I think is why he thought it wasn't going to be such a big deal. As reported as a possible, it would have been a big deal. This says, actually, when you look at the detail, the cash accounts were okay, but there was a problem with harvesting individual transactions, which would have been an issue for the post office reconciling with its clients in a timely fashion. So that's the most of it. That the bottom paragraph, POCL has to remove the aspect concerning reference data change from core to non-core. That was included in the numbers that had been considered at the outset, but it was a very particular problem that occurred back in June, I believe.
June 99.
June 99, which I referred to earlier as being a reference, the first of the reference data pinnacles that we flagged. And this had to do with, as I recall, sign change. This will probably come up again later, whereby there's a convention around signage plus or minus, and if you get it wrong, you get an error times 2, in actual fact. You don't actually nullify it, you just get it the wrong way around, so instead of adding it, you subtract it. And that's going to throw out a cash account, and that's potentially very serious. But all of that is driven by reference data. Should I just describe what reference?
No, we know what reference
You
data
know what
is.
that is.
Thank you. Can we move down the action, please? Sorry, down the AI, please. And a bit more, please. Thank you. Clearance action, box 7. The fix to reconstitute missing transaction attributes was introduced 3rd of August. Pathway confirms that at the time of completing this analysis, no further missing transactions have been noted to date by Pathway internal monitoring, subject to satisfactory processing by TIP of the cash account for week 19 in line with the reduced incident rate proposed by Pathway and with the above procedures in place to notify any exceptions. Pathway assessed the severity of the incident as low. Ongoing monitoring for the next 3 months should progressively reduce occurrence to a maximum of 0.1%, at which point the incident be closed. Mr. Pope has written his name, or his name is written, next to I propose the clearance action and incident status described above. Incident status resolved 11th of August 1999. So is that essentially Mr. Pope signing this AI off as resolved 3 weeks after the AI had been opened?
He's proposing that it should be regarded as resolved, but it can't be resolved without the agreement of the Post Office.
And where should we see their signature?
Does it not go on?
Yeah, so underneath, I accept or reject. Can you see that?
Yes.
That's where we should see.
So that's where you should see a rejection by POCL.
And so the proposal was from ICL Pathway that this can be cleared in 3 months' time if incidents progressively reduce to an occurrence of a maximum of 0.1%. Is that 0.1% per week?
Yes.
Per cash accounting period?
Yes, it would be. And I'm guessing the reason that there's no corresponding POCL signature is because who's to say whether it was going to be achieved, this 0.1% proposition, within 3 months? At the point where this was written, no one would have known that.
What do you say is to the suggestion that a 3-month monitoring period was short-sighted or ill-advised when the national rollout was yet to commence, and so the sample size was small?
So the sample size was increased by 1,800 in the period September-October 99. So by the end of the 3-month period, you were up at 2,100 from memory. So it was a decent sample size, and it was a very good thing that the 1,800 were rolled out because it gave a lot bigger sample size and a lot more feedback. It also exercised in earnest the reference data system, which had been subject to a freeze for a period, and that was possible when you weren't adding post offices. As soon as you add post offices, you have to add new reference data because you have reference data by post office. So you couldn't freeze it. There'd been a moratorium because there'd been these reliability issues. So I personally think a sample size of 2,100 for 3 months is not unreasonable.
If do you read this as meaning that after the end of that 3-month period, it would be acceptable for the full post office estate, some 19 or 20,000 branches, for the system to continue to operate at an error occurrence rate of 0.1%?
If POCL felt they could manage it because it was not affecting the cash account, right, subject to that condition, I would say yes, because, as I said, the practical reality was we were dealing with 25 years ago technology to gather millions of transactions a day, and you're going to get some glitches. It's just anybody in the, involved in that program must have realized that on both sides of the fence. So you have to allow for that possibility. You can't have 100% SLAs and 0 instances of failure. It's just not the real world, I'm afraid. The question is what you do about it and how you contain it, how you flag it, how you protect stakeholders when this does happen. Here, this is not an error. This asserts in there's no errors in the cash account. And there would be errors in the cash account, but that's a different matter.
Can I draw your attention to another document, please? POL 3083922. At page 5, please. And if we can just enlarge that, please, because it's on a fax and therefore has reduced in size a little. I wonder whether we can display 2 documents at once. So keep that one and look at the document we were just looking at, which was POL 3043691 at page 57. Page 57. And then try and highlight. Thank you very much. The document on the right we can see is another copy of AI 376. Can you see that?
Yes.
And we can broadly see, certainly in box 6, sorry, can we, on the page on the right, can we go back a page, please? And then highlight the relevant section. Thank you. We can broadly see that they are the same. If you just look at the data on the left-hand side and the right-hand side.
Yep.
In fact, I think
they are the same, aren't they?
They are identical. And there's some colour differences, but or shading differences. And then if we scroll down both of them, please. We can see that the data within them is the same. Yes?
Yes.
And then if we go over the page for both of them, please. we can see that box 4 is different. It says medium rather than low. And box 6 is entirely different. It's just got completely different text in it.
After 20,000 outlets, yes. So one looks like an update on the other. Firstly, there's a causal analysis that there are two causes.
Yes, if we read that, there are two causes. Very occasionally a transaction is recorded at the outlet with a missing attribute, start time or mode. The processing rules specified for the TPS harvester rejects any transaction which has a missing attribute, meaning that these transactions are not forwarded to TIP. They are, however, correctly posted in cash accounting processing. The harvester specification is being modified to 1, reconstitute any missing start time attribute by interpolation from immediately preceding transactions within the customer session, or if none is present, to log an event, and 2, map any, I think, full mode? Null mode, thank you, attribute to, quote, serve customer attribute. I'll skip the next bit. Pathway will monitor occurrences of any such null attributes, and work will continue to ensure that all transactions are correctly recorded with all attributes at the outlet. This will eliminate this problem. It's theoretically possible that a very occasional transaction will result with an invalid item transaction mode, although there has been no instance of this detected in any of the analysed cases. Second cause, on one occasion a reference data change from core to non-core and the new reference data mapping of products to cash account may cause transactions conducted within the cash accounting period prior to the reference data changes or not to be posted to the cash account. In this case, there's no fault with the Pathway system. Pathway has proposed an approach to POCL to avoid this problem through the use of product types within RD. That last sentence bears some similarity to what had happened, or what was described in the document that I showed you earlier. Can you explain, please, is this how these forms worked, that there could be something written in one version of an acceptance incident that could be deleted and then something new could be written into it, rather than a progressive chronological account of the development of the problem and the solutions to it?
I am surprised to see this. I would have expected exactly what you just described.
And why are you surprised to see it?
Because the documents I looked at, I didn't go through all of these. I went through the Excel spreadsheets that I was describing earlier, which are the register, and those showed day by day, sequentially, everything that happened. Who said what actions had been taken, what actions were placed, who responded to what actions, how, on both sides, and because these were joint activities. So there was no question there of anything being wiped or written
Deleted
over.
or overwritten?
Exactly, no question at all. I'm surprised to see this here, I must admit.
And then if we can read on to, in both documents, down to the clearance. Thank you. And then on the right-hand side, thank you. Just a bit more. Thank you. I think we can see that there's a different clearance action in this document. We can see that it's signed off by Mr. Dix himself. You remember that under the document I showed you earlier, the proposal was of acceptable occurrence was 0.1% per week over a 3-month period. This proposal was that the relevant period would be a single cash accounting period. I think that's 1 week rather than 3 months. Yes?
Yeah, I'm reading this, I think, for
You're
the
just catching up, okay.
first time. Yeah, I'm not familiar with this one. I don't think. So the conclusion is, the proposition for what it should be, still the same, ongoing monitoring for 3 months, 0.1%. So that's no difference. But this was clearly an interim position as at the 9th of August, which was then replaced on the 11th of August. Now, I don't know whether the version as at the 9th was shared with POCL. It's possible that the reason it was overwritten, as you say, is because it hadn't been shared. So events had moved on, the bug fix had been applied, had been successful, whereas on the 9th it was still a work in progress. So that's the best I can do by way of explanation, I'm afraid.
In the clearance section, it says for excuse me, for ongoing monitoring, Pathway believe a target maximum occurrence due to this cause for the next cash accounting period should be at 0.67%, at which point the incident should be reduced to medium. And then the ongoing monitoring at 0.1%, at which point the incident should be closed.
So that implies to me that it was viewed by POCL as high. John Dix was saying we've made good headway here. We think it's now already medium. And if it proves, if events prove over the next 3 months that it actually has pretty much gone away and POCL are happy with 0.1%, then it should be closed. That's my interpretation of this.
Is that a practical demonstration of ICL considering the cash account discrepancies to be less severe than POCL?
No, this isn't, as I see it, to do with the cash account. This is to do with these attributes, these missing attributes, and the fact that TIP would reject transactions with missing attributes. That's why TIP was missing transactions, and those transactions had been included in the cash account, is what this makes clear. And there was, as I understand it, no argument about that. That's not to say there weren't other issues, but not in relation to this.
Okay, we can take both of those documents down from the screen now. Can we turn to what was happening in the midst of this, namely the signing of the first supplemental agreement, and look at Fujitsu 50485. Can you see the date of the first supplemental agreement, the 20th of August 1999?
Yes.
And can we just read the preamble together? So under recitals. Thank you. This supplemental agreement is supplemental to the codified agreement between the parties of the 28th of July 1999. The contractor and POCL have been carrying out the operational trial and the other acceptance procedures in accordance with the codified agreement. It's agreed that at the end of the CSR operational trial period, there were, and then if we just scroll down please so we can see them all, 9 faults, the agreed category B faults, which both parties agree are medium, and then they're listed. 3 faults, disputed category A faults, which the contractor, that's Pathway, considers to be category B faults, but which POCL believes are high severity category A faults. They're listed, and amongst them is 376. So is it fair to say that at this date, despite what we had read in the AIs of the 9th and 11th of August, by the 20th of August, there remained a dispute about the severity of AI 376?
Yes.
And was that relatively common during the resolution of the AIs? Because in part, ICL were permitted no category A incidents, and as you said, only 10 category B incidents, and upon which classification acceptance turned and therefore payment to ICL turned?
So, relatively common, no. They were exceptional. There were 3 where we didn't agree. And if I may, on 376, there was no disagreement that if the cash account was going to be wrong, that was a serious issue. The reason that ICL Pathway considered it not to be their serious issue is because they attributed most of the problem to reference data, which came from POCL. So that was, if you just go back to the bottom paragraph of the previous report, it was saying this is excluding the reference data issue. The reference data issue was really serious because that would have caused a cash account problem. But ICL Pathway's position, at certainly the technical level, was this is not our problem. Now, at my level, it's a problem because the end result is going to be wrong for the collective. And you may come on to this later. John Bennett wrote in, I think it was early November, to David Smith about this very issue. And he more or less said, unless you can fix it with us, we can't do it on our own, we're going to have to stop rollout. That was ICL Pathway to POCL on reference data.
Just on the issue of there only being 3 disputes, I think we can see underneath there were 2 faults which were disputed category B faults.
Point taken.
Which the contractor considered to be low, but which Pockle believed to be B, and then over the page, more dispute. So there were 2 of those, and 1 fault, which ICL believes isn't an acceptance incident at all, but which Pockle believes is a category B fault.
I stand corrected. There were 6 disputes out of, as you pointed out, scores and quite possibly hundreds.
There's 6 disputed faults.
Yes. I don't regard that as common out of so many when so much was moving. And it was acknowledged that there was a disagreement. And ultimately, we accepted that we hadn't passed, hence the supplemental agreement.
Can we just move on over the page, please, to paragraph D of the preamble? It is agreed that there is no CSR acceptance specification in respect of which there are more than 10 category B faults. Just explain what that means.
If there are more than 10 category B faults, then we fail.
And so it was recording the agreement that there were not in excess of 10.
Yes.
And then if we can read down, please, to the agreement itself after the preamble. 1.1 under CSR acceptance. The parties agree that CSR acceptance was not achieved as at the end of the CSR operational trial review period. So
yeah, that's what I just said. Absolutely. Yes. We accepted that.
So it was agreed that the core system didn't meet the acceptance criteria at the end of the operational trial.
Correct.
And as we will see after lunch, I think, when we look at pages 7 and 8 of this document, there was nonetheless a timetable for new installations to be ramped up in post offices. Is that right?
There was, and I alluded to this earlier. Part of the logic for that was that we needed a bigger sample size. To your point about 200 not really being sufficient, or was it 300 by then? But and we needed experience of the rollout process itself, because migrating data from existing paper-based system to the new system, that of itself could generate problems. So we needed to really test our abilities jointly with Post Office to roll this thing out without hitting the wall. And that was the proposition that that happen in October, November, sorry, September, October, November, such that we would then have a period of time before January resumption of rollout to fix things that were found. That was the thinking.
So I wonder whether that's an appropriate moment to break for lunch. It is for me.
Yes, I think it is. I'm sure you're aware, Mr. Oppenheim, but you shouldn't discuss your evidence while you're having your lunch. I'm sure you don't want to, but I'm obliged to tell you that.
Thank you, sir. Yeah, I'm aware of that.
Yeah. All right, 2 o'clock, everyone. Thanks.
Thank you, sir.